think we're now ready to resume the hearing of the appeal in the case of Bresco and Lonsdale. Ms. Sinclair, whenever you're ready.
Thank you, my lords. Having spent a little time this morning surveying the relevant legislation and some of the case law, my lords, I hope I can condense my submissions on the cross appeal on the jurisdiction issue quite considerably. We submit that Lord Justice Coulson concluded erroneously based on a quotation out of context from recalcing that shows as an action which existed at the insolvency date survived for all purposes the insolvency. But ultimately, he decided the jurisdiction issue on very narrow grounds. He began with what he understood to be a concession by Lonsdale that Bresco could have referred the same claim to adjudication. He reasoned that if the contractual right to refer the claim to arbitration survived liquidation, then the underlying claim must continue to exist for the purposes, well, for all purposes, and that those purposes included adjudication. He said it was irrelevant that adjudication would not produce a final decision, and anyway it might do so, not least because the parties might not challenge it. We say the decision was wrong for three principal reasons. First of all, it's apparent that, with all due respect, Lord Justice Coulson overstated the concession which Lonsdale made. I just invite you to, and I won't turn them up, but to compare paragraphs 20 and paragraphs 36 of Lonsdale's skeleton below. Those are pages 371 and 378 of the core bundle. At paragraph 20, Lonsdale's submission was that Bresco should have, or all that Bresco had to refer was a claim to the net balance, and that was not what it had referred. It had referred a conventional claim. So that submission was plainly made, and the concession made was that Bresco could have referred not the claim which in fact it made, but a claim to the net balance in arbitration. Well, the second reason why the Court of Appeal's decision was wrong is quite regardless of that point about the concession. Even assuming a concession that Bresco could have referred this claim to arbitration, the court was wrong to move from the position that a claim which was simply one element of the statutory account could be referred to arbitration to a conclusion that it could therefore be referred to adjudication using a similar contractual right. And the reason that is wrong is because it treats arbitration and adjudication as materially similar processes. As I sought to explain this morning, they are not even closely analogous processes, to use Mr. Justice Dyson's language. In particular, adjudication does not satisfy the three cardinal requirements for the taking of the statutory account. Looking at adjudication from the point of view of the insolvency legislation, first of all, it's not comprehensive because of the limits upon what can be referred. It's not difficult to think of examples. I mentioned the cardinal example this morning, which is the smash and grab adjudication in S&T and Grove developments. A technicality leads to a decision that an immediate payment must be made. It has nothing to do with the ultimate rights of the parties vis-à-vis each other, as it is not a valuation of the work done, which is ultimately what the employer agrees to pay for. Other examples, parties to a construction contract may well have claims against each other under other contracts. quite easy to imagine that people develop commercial relationships which lead to several contracts on different projects, particularly subcontractors. Separate adjudications would be required, at the very least, for each of those disputes under each of those contracts. The parties may have mutual dealings which have nothing to do with construction contracts as defined by the Construction Act. They may have dealings under pure supply contracts, under residential occupier contracts. They may have dealings, for example, one example that occurs to us is where a builder and a developer enter into a joint venture type agreement, and they make two contracts. One is a building contract, a construction contract, which includes the adjudication provisions under the Act. The other is an agreement which regulates their financial dealings, the sale back, for example, or the lease back. That will not be a construction contract. So if those parties have claims and cross-claims arising out of their purely financial agreements, those would not be amenable to adjudication. So my lord, adjudications, it's not comprehensive, as the account we say requires. Secondly, it's not reliable. I made the points earlier this morning, and you've seen them in the authorities. Adjudication is not intended to provide a correct decision. It's intended to provide a quick one, because that serves the objectives of participants in construction projects. Now, I anticipate that Bresco will suggest that it's unobjectionable for a liquidator to use adjudication, in effect, as a way of stress testing his claim, or the parties' mutual claims, of testing them out, assessing their risks. We say that's an entirely inappropriate use of adjudication. The insolvency legislation makes no provision for it, first of all. What the insolvency legislation does require is that the liquidator estimate a debt which is contingent or unascertained or uncertain in value for any reason. Normally, the liquidator does that by taking appropriate professional advice, and then he makes his estimate as the legislation requires him to do. That's rule 14.4 at page 577. Lord, the legislation also provides what is to happen if there is any dispute about that estimate, and it provides that the court is to examine the estimate. That's section 168 of the Insolvency Act. That's at page 443 in the bundle, but I'm afraid for some reason we've lost the relevant subsections, which are subsection 3 and subsection 5. We'll make sure that they are added. Or if the estimate results in the rejection of the creditor's proof, or the admission of the proof in a lower amount than the creditor is satisfied with, then the insolvency legislation makes provision for an appeal to the court. And that is under rule 14.8 at page 575. Standing back from the insolvencies legislation, one might ask, well, is there not still a value in adjudication? It's a run through, it's a practice, it's a stress testing process. There isn't, because that process has no value over and above taking appropriate professional advice in the usual way from an appropriately qualified person. It has no value unless the other side participates. Now, my lords, you have seen that in this contract, whether or not it participated, Lonsdale was going to be liable for half of the adjudicator's fees and expenses. So even if it decided that it would have nothing to do with the stress testing process, it was still going to be paying for it. And indeed, the other half, that since the liability was joint and several, if the adjudicator went to the liquidator and didn't recover the liquidator's half of the fees and expenses because there weren't sufficient assets to fund those as expenses of the liquidation, then the full liability for fees and expenses would come back to the non-participating responding or non-responding party. So, my Lord, we say, in fact, the Court of Appeal was right in the part of its judgment. I'm sorry, my Lord.
Just on a small point, the liquidators, if he incurred half the cost of an adjudication, that would be a liquidation expense, wouldn't it?
My Lord, yes. But
So,
there needs to either be provision for that
yes.
expense in advance, or there need to be sufficient assets.
Yes. But they would come off the top if there was any recoveries being made in the liquidation at all.
Yes, after the fixed charges.
Yes. Yes. Yeah, thank you.
No, I accept that. So it's not comprehensive. It's not appropriate to treat adjudication as a trial run or as some way of assisting the estimate. And the Court of Appeal was right to reject the suggestion that adjudication could stand in for the liquidator's estimate. It did that at page 258 in the injunction part of the judgment. The third reason why adjudication is not apt for taking the statutory account is that it does not produce a final determination. And the reason why that is important it is because the liquidator's duty under the insolvency legislation is to get in and to distribute the assets of the company. It's a serious obligation. It should be done carefully, with reasonable accuracy, and with finality, subject to the power of the court upon appeal or upon application by the creditor as provided for in the rules and in the sections I just mentioned to review what the liquidator has done. There is no room in the insolvency legislation for a provisional procedure. My Lord, the third reason why the third reason why the Court of Appeal was wrong was that it did not. I'm sorry, my Lord. Yes.
I just wanted to, don't some of your arguments prove too much? I mean, on that last point, taken to its logical conclusion, the liquidator would have to take to court every single dispute, and he couldn't resolve it with anything less than a final determination.
No, my Lord, our submission is that the insolvency legislation places upon the liquidator himself first and foremost the obligation to take an account with finality. It then provides, if there is dissatisfaction, for the court to have power upon application or appeal to review what the liquidator has done. Well, the third reason why the Court of Appeal was wrong was that it did not even address, let alone answer, the submission which was made to it that a dispute as to the net balance after insolvency set-off was not a dispute arising under the contract within the meaning of Section 108 of the Construction Act. The argument was clearly made. The page reference is Core Bundle 376. It was addressed by Mr. Justice Fraser at first instance. We've quoted from his judgment at Core Bundle 207, and you can see it in the judgment at page 243. We say the right answer is that a dispute as to the net balance is not a dispute arising under the contract within the meaning of Section 108. First of all, on the ordinary meaning of the words, a dispute generated by Rule 14.25 of the insolvency rules is not a dispute arising under the contract. It is arising under the insolvency rules. it is a dispute which encompasses far more than the parties' claims and cross-claims under the particular contract. It includes far more than causes of action which might happen to have crystallised by the time of the liquidation, by the liquidation date. My Lord, the other aspect of this of statutory construction, of course, is the purpose of the statute. The clear purpose of the introduction of the adjudication regime was to provide a pay now, argue later mechanism. Once a company is in liquidation, the purpose and the policy behind the Construction Act cease to apply. Cash flow, for example, is unimportant to it. It is no longer a participant in a construction project. So the other objectives of assisting projects not to become dispute bound, assisting parties to resolve their disputes swiftly and provisionally, doesn't apply. And we say there's nothing, my Lord.
Can I just test that? You can hear all right?
Yes, I can.
That last submission you've made would be equally true, wouldn't it, if there was no cross-claim and the liquidator was simply seeking to pursue a naked claim, naked in the sense that it's not met by a cross-claim, by way of adjudication. I don't think you submit that there is no jurisdiction in that situation.
No, my Lord, I don't.
And therefore, if the proposition that, well, that wasn't really what the Act was for, and liquidators don't really need cash flow, and liquidators looking finality, were all reasons why an adjudicator has no jurisdiction where there's a liquidation situation. Why is it of force where there's a cross-claim, but of no force where there isn't a cross-claim?
My Lord, I don't say that it's of no force, but I don't need to go that far. I only need to persuade you that where insolvency set-off is in play or has operated, there is nothing in the Construction Act to suggest that adjudication has a part to play. My Lord Legate has a...
In terms of the Construction Act, it would have been very easy, wouldn't it, if the intention had been, if the concern had been all about cash flow, limit the scope of adjudication to stage payments or disputes about pay now, argue later, etc. But you accepted earlier that adjudication under the Act applies after the whole project is over, when there isn't the cash flow concern.
My Lord,
it follows, doesn't it, that is not a good reason why the Act should be interpreted as narrowly as you suggest.
My Lord, I do accept that in terms of the objectives of the Construction Act, cash flow is not the only objective. Other countries have taken, in the light of our experience, perhaps have taken a narrower view and restricted their legislation to payment obligations during the project only. I accept entirely that was not the case taken in this country. Nonetheless, in my submission, it cannot be ignored that the primary objective of adjudication is to assist parties during a project. That is the principal benefit of having a speedy provisional decision-making mechanism. And in a sense, one argues back from the characteristics of adjudication. It is unique. There is, so far as we know, in this jurisdiction, no comparable process which arrives at a result which is binding pending a final determination. It was brought in for a particular reason, and the particular reason is that time is money on a project. Disputes waste money and waste time. Well, if one focuses on that primary objective, my submission, one sees why adjudication is the way it is, with the key features that I identified this morning. Sorry, that's my printer. My Lord, as a footnote, I would just draw your attention to the fact that the position in, I'm so sorry, somebody is using my printer remotely. Lord Hamlin has a...
Yes, you say that dispute in relation to a net balance. It's not a dispute under the contract. As I understand it, you accept the net balance dispute could be referred to arbitration. That could only be because it was a dispute under the contract in which the arbitration clause is contained. Is that not right?
My Lord, that is right.
What's the difference?
What is the difference?
As a matter of construction.
Well, perhaps I'm not understanding the question. A dispute.
You say dispute under the contract. Dispute under net balance is not dispute under the contract for the purpose of section 108.
Yes.
As I understand it, you would accept that it's a dispute under the contract for the purpose of an arbitration clause.
Yes, I'm so sorry.
Disputes under the contract. So I'm just wondering what as a matter of construction, what the difference is.
My Lord, as a matter of purely the wording, then I would revert to the submission I made earlier that it's not actually a dispute arising. Well, it arises under the insolvency legislation. I take the point that it would arise under the contract for the purposes of a suitably worded arbitration clause. That's the way that we put it in our written case.
Which means what?
Well, one can imagine arguments where a tightly drawn arbitration clause would exclude statutory disputes arising out of statutory entitlements. One sees some arbitration clauses that are expressly wide enough to cover disputes such as this. One sees others which seek to confine matters. So it would always depend upon the nature of the rest of the arbitration clause. But as a matter of principle, my Lord, we accept that because arbitration is final, because there are not the same limits on what can be included within the scope of an arbitration award, always assuming that all of the parties' mutual dealings arise under that one contract. Otherwise, then you have problems with arbitration too. But its finality and its comprehensiveness and its normally reliability make it an apt forum to determine the net balance. And in those,
if your arbitration clause required you to mediate first, could the liquidator insist on that?
Well, my Lord, yes, there was a contractual right to mediate, then yes.
Right, even though that wouldn't be final in any sense.
Well, mediation is not a dispute decision-making process, my Lord. It's simply a procedure. I was just going to mention the position taken in other jurisdictions, notably in Victoria, the Court of Appeal in the case of facade treatment engineering and multiplex has held that there is an inconsistency between insolvency set-off and a statute there which permits summary judgment on interim payment obligations. Well, I won't, for reasons of time, I won't take you to it, but if I might give you the page references, the decision is at page 2585, Court of Appeal of Victoria in 2016, and the relevant passages are paragraphs 178 to 179, pages 3120 to 3121. Other jurisdictions have done things differently. In New South Wales, for example, The most recent Building and Construction Industry Security of Payments Act provides in terms that a company in liquidation cannot refer a dispute under a building contract to adjudication. So they have, as it were, preempted the whole argument. They have taken the point, as my Lord Briggs suggested it might be taken, all the way to prevent any claimant in liquidation from enforcing from using adjudication process. And we've set that out in paragraph 98 of our written case at Core Bundle 219. Well, for those reasons, we invite you to find that the Court of Appeal was wrong to find that where there are claims and cross-claims, one of the parties is a company in liquidation, that a construction adjudicator has jurisdiction to decide a dispute between those parties. I would come on, if I may, to the appeal, the utility or injunction issue. The starting point is to be clear about what the Court of Appeal decided. There are suggestions in Bresco's written case that what the Court of Appeal did here was to impose a blanket anti-adjudication rule against liquidators. That isn't what it did. The court made very clear that there must be a cross-claim, otherwise insolvency set-off is not engaged. And that's made clear at paragraphs 46, 47, 54, 58 and 60. The court also noted that in the present case, the cross-claim, albeit under the same contract, overtopped the claim. That's paragraph 10 of the Court of Appeal's judgment. So the Court of Appeal did not decide that liquidators can never use adjudication. That is not a question which arises in this case. Indeed, only disputes which would lead to adjudication decisions with immediate payment consequences are caught, because otherwise insolvency set-off is not engaged. For example, a claim for delivery up of goods is outside the scope of insolvency set-off. There must be a commensurable liability. Claims for declarations in the main will not be caught because, well, one can imagine numerous types of claims for declaration which have no immediate payment consequences. Very commonly in the context of a building project conducted perhaps on a costs or a reimbursement basis, there is an entitlement in the employer to audit or to delivery up of the contractor's records. And there are commonly disputes about that sort of thing, and declarations are commonly sought. That's outside of the approach to injunction which the Court of Appeal adopted. Indeed, even a claim for a declaration that one or other party had repudiated the contract, in many cases would have no immediate payment consequences because there would still be disagreement about the amount of either payment or damages which followed. Thirdly, my lord, it's suggested that in fashioning what it calls this blanket anti-adjudication rule, the Court of Appeal went wrong in that it should have postponed the question about what to do with the adjudication where insolvency set-off was engaged to the enforcement stage when it said a fact-sensitive and nuanced approach could be taken. My lord, what the Court of Appeal did in this case was precisely to take a fact-sensitive and nuanced approach. It simply took that approach at a sensibly early stage before parties had incurred what can be the very considerable costs of an adjudication which was never going to be enforced. The Court of Appeal granted the injunction which it did in this case on the grounds of precisely practical utility, or rather futility. And in the subsequent decisions at first instance applying the Court of Appeal's judgment, one can see that this works, and with respect to the Court of Appeal, it works very well. There are two more recent decisions. They recognise in terms that the Court of Appeal's finding that adjudication and insolvency set-off are incompatible regimes, which was the basis of its decision on the adjudication issue, stem from three principal concerns. The first concern is that normally adjudication will not be a forum where the net balance between the parties, between company and creditor, will be decided. That has the consequence on the authorities that the decision is not going to be enforced. That's common ground between the parties. The second concern is that the enforcement, if the adjudication decision were enforced, it would deprive the creditor of the benefit of insolvency set-off. And the third concern is that it's inherent in adjudication that an adjudication decision is enforced without prejudice to the party's substantive rights. In other words, it doesn't prejudice the availability of a final determination by litigation, arbitration, or agreement. What the first instance decisions show is that those three concerns can be accommodated. And if those concerns are accommodated, then the adjudication is not restrained in accordance with the decision of the Court of Appeal. Whether those concerns are accommodated on the facts of a particular case is a fact-sensitive inquiry. And so the simple question becomes, should we have that inquiry before parties spend a great deal of money and management time and professional fees on adjudication to see whether those three concerns are allayed, or should we wait until the expenditure has been made? Perhaps I could take you to the first of those two decisions. It's Meadowcraft Building Developments in 12-8 Hill Street. It's in the authorities bundle at page 1016. Now, in that case, the point was actually taken at enforcement stage, not as an injunction. But the decision of Mr. Adam Constable QC, sitting as a deputy judge in the Technology and Construction Court, is a very detailed and with respect, thorough consideration of the Court of Appeal's decision on injunction in this case. At page 1035, the judge encapsulated the three underlying concerns which I've mentioned. This is paragraph 87 on page 1035. And he explained what might be done to allay those concerns and allow the adjudication to proceed. The first, paragraph 87.1, is that the proposed adjudication must determine the final net position between the parties under the relevant contract. So that addresses the concern as to the comprehensiveness of the adjudication as a way to determine the net balance. That's a factual inquiry because it depends what the disputes between the parties are, whether they amount to no more than one dispute under one construction contract, and whether therefore they can be brought within the scope of adjudication. Secondly, the question of satisfactory security. That the requirement for that stems from the court's concern in this case that if an adjudication decision were to be enforced, it would deprive the creditor of the benefit of statutory set-off. He would, instead of being able to set off the company's debt to him, pound for pound, against his debt to the company, he would have to prove for his entire claim against the company in the liquidation. That can be dealt with by the provision of security at 2A, in respect of any sum awarded in the adjudication and successfully enforced, so that it is repayable should the responding party successfully overturn the decision in litigation or arbitration brought within a reasonable time of the date of enforcement. And B, in respect of any adverse order for costs made against or agreed by the company in liquidation in favour of the responding party, in respect of 1, any unsuccessful application to enforce the adjudication decision, that's the summary judgment stage, and 2, the subsequent litigation / arbitration in which the responding party is seeking to overturn the adjudication decision. And the third concern, which is the preservation of the availability of final determination, is addressed in little paragraph 3. That is the concern that the adjudication regime does not envisage that adjudication will make final determination more difficult. But in effect, if an adjudication decision is made where insolvency set-off applies in favour of a company in liquidation, then a provisional decision, formally speaking, becomes a final decision, practically speaking. And it does so because if the solvent party is the losing party in the adjudication, then not only does he face the prospect of having to prove in the liquidation for his claim, but he's exposed in the same way to the full costs of any final determination he might seek, because he's going to have to prove for any costs award in his favour if he wins on the final determination. Now, safeguards can be put in place to protect him against those risks, and they're described as little 3 on page 1035. The judge said a combination of the following solutions might be appropriate. A, the liquidator undertaking to the court to ring fence the sum enforced so that it's not available for distribution for the relevant duration. B, third party providing a guarantee or a bond. And C, after the event, insurance. My lord, that was a case, like the present case, where the liquidator sought to refer a claim to adjudication with funding from an entity known as Pythagoras Capital, which is rewarded for its financial support by a share of the percentage of the proceeds. Now, in that case, the adjudication decision was not enforced because although some measures had been offered, they were not satisfactory to the court. In the present case, nothing was offered at all by the time that the Court of Appeal came to consider this case. So none of these measures at all were offered. Nothing to allay the concerns which led the court to restrain the adjudication. My lord, the second decision since the decision of the Court of Appeal is Balfour Beatty Civil Engineering and Aztec Projects. That's at page 604, and I don't ask you to turn it up, but may I give you a page reference? That was an injunction application. At paragraph 8 on page 607, Mr. Justice Waxman referred to paragraph 89 of Meadowside, to which I've just taken you, and described those as the Meadowside conditions. And he said, as did the judge in Meadowside, if those conditions are satisfied, then the case is an exceptional case to which the approach to injunction, which the Court of Appeal decided in Bresco and Lonsdale, will not apply. In that case, ultimately, Mr. Justice Waxman refused injunctions in relation to 3 adjudications, but he did so on a lengthy series of conditions, which are set out at page 613, which in a very similar way, the liquidator had already offered to ring fence the principal sum. It had offered £250,000 security for costs in relation to one of the adjudications, and the judge said another £250,000 will be provided in security for each of the others, and a number of other conditions as to time to make sure that the parties got on with it. Now, those decisions, in my submission, demonstrate an eminently fact-sensitive and nuanced approach to the exercise of the power to restrain an adjudication. It works, in other words. Now, Bresco says, well, that the liquidator shouldn't have to pay a price in order to adjudicate. My lord, it's the price of using adjudication for a purpose for which it was not designed. It's the price of using adjudication when you know that you're going to get a decision which the court will not enforce, because the court will not enforce a decision in favour of a party in liquidation. It's also a cost of business for those who fund adjudications brought by liquidators in these sorts of circumstances. And I think it can certainly be said with some confidence that adjudication was not designed or intended to generate a market in distressed debt in the construction sector. On ordinary principles, funders are expected to cover the downsides as well as the upsides, and it's appropriate that that is done at an early stage. So, my lord, that is the ambit of the court's decision, and that is how it works well in practice. Returning to the basis of the challenge, as I say, we understand it to be common ground that an adjudication decision will not be enforced by the court if the claimant is in liquidation. The principal authority for that is Bouygues and Dahl Jensen in the Court of Appeal, which is quoted in the Court of Appeal's judgment. So I should just give you the it's paragraph 20 of the Court of Appeal's judgment at core bundle, page 250. It's paragraphs 33 to 36 of the decision of the judgment of Lord Justice Chadwick in Bouygues. And Lord Justice Buxton agreed with that analysis. I won't take you to it because it's a decision that is repeated in so many authorities. It's at page 622 in the authorities bundle. And Lord Justice Buxton at paragraph 15, page 626, agrees. And Lord Justice Peter Gibson at page 631 agrees with both judgments. The question of enforcement was also recognised and subjected to a very, with respect, careful and detailed treatment in Straw Realisations and Shaftesbury House, a decision of Mr. Justice Edward Stewart, which you have at page 24, I'll start that again, I'm so sorry, 2419. And it's pages 2432 to 2437 in that judgment. Now, in consequence of that, Lord Justice Coulson, we say rightly, reached the conclusion that an adjudication which would lead to an unenforceable decision is an exercise in futility, and it's appropriate to restrain it in all but the exceptional case where the concerns he expressed are not addressed in the way we've seen in Meadowcraft, for example. Now, on this appeal, but not below, Bresco argues that the principles applicable to anti-suit injunctions or anti-arbitration injunctions apply, and it says that the Court of Appeal erred because it did not apply those principles. Our submission is that those principles do not apply, but even if they do, the injunction in this case was compliant with them. We say, first of all, that they don't apply, simply because there is no reason to apply those principles in the context with which the court is here concerned. The power under section 37(1) of the Senior Courts Act 1981 is expressed in broad terms. The power is to grant an injunction in all cases in which it appears to the court to be just and convenient to do so. In different categories of case, in different legal contexts, the court has developed different principles for the exercise of that jurisdiction. Here, the court followed the approach in Twintech and Volker Fitzpatrick, which you have, you have that at page 1372 in the authorities. The decision of, again, Mr. Justice Edward Stewart in 2014. The judge in that case concluded that the adjudication which had been commenced would not produce an enforceable decision. Now, he did that in that particular case because there was a jurisdiction defect. At the moment, of course, I'm assuming that I lose on the cross appeal. You find against me on jurisdiction. But it doesn't actually matter, in my submission, why the decision won't be enforced. What matters is that the adjudication which the court is considering will not produce an enforceable decision. And the court found that in those circumstances, it was appropriate, first of all, to intervene before the enforcement stage, before everybody had spent time and money on the adjudication. And secondly, he specifically rejected the submission that the principles derived from the anti-suit injunction cases should apply. First of all, at paragraph 62 to 64 on page 1381, the judge addressed the submission and rejected the submission that the right time to consider all of this was the enforcement stage. The adjudication should continue. And I would invite your lordships to read paragraphs 63, 64 and 65, 66 on that page. My lords, that was a case where an adjudication had been started on a dispute which was already the subject of court proceedings. And so one of the lines of attack had been that that was oppressive and vexatious. And you will recognise the resonance with the cases on anti-suit and anti-arbitration injunctions. Paragraph 72 of his judgment on page 1382, Mr. Justice Edward Stewart expressly rejected the applicability of such principles in this context. He rejected them because in the anti-suit injunction or anti-arbitration injunction cases, the court was considering proceedings which would bind the parties finally, whereas that was not the case here. He was right in our submission to reject the application of the principles here, not merely because the court is not here concerned with alternative proceedings which will finally bind the parties, but also because there are numerous other considerations which are significant in the context of anti-suit or anti-arbitration injunctions, which are simply have no part to play in the current context. For example, in the context of anti-arbitration injunctions, the court has to pay due regard to the requirement of the Arbitration Act that the parties' freely consensual choice of forum for final dispute resolution should be respected, and the court should not intervene except as permitted by the Act. Well, adjudication is not the result of a free bargain. It is the result of the application of the Construction Act. The second constraint in the anti-arbitration cases is that, as a principle of international arbitration law, the arbitrator has jurisdiction to decide his own jurisdiction, competence. That does not apply in adjudication. An adjudicator doesn't, under the statute or the scheme, have power to decide his own jurisdiction. Parties might confer it upon him if they wish to do so, otherwise he doesn't have it. And my lord, so far as anti-suit injunctions are concerned, certainly those concerning foreign proceedings, there is a very significant constraint in the form of comity between states, which in a similar way tends to inhibit the grant of injunctions, which doesn't operate in this particular context at all. So we say that those differences mean that it's appropriate that the principles governing anti-adjudication injunctions be different from and less demanding than those which govern anti-suit injunctions or anti-arbitration injunctions. And that in Twintec, Mr. Justice Edward Stewart was quite right to conclude, as he did, that provided the court is satisfied that it is just and convenient to grant an injunction, then it is appropriate for it to do so where the adjudication which would otherwise proceed will not be enforced and is an exercise in futility. If it is necessary to look beyond Twintec, we say a far closer analogy might be found in the jurisdiction relating to injunctions to restrain the presentation of winding up petitions, like adjudication, a domestic matter, normally. The principles developed in the context of anti-suit and anti-arbitration injunctions do not apply in that context. In the bundle, we have an extract from Raphael on anti-suit injunctions, which is a helpful potted summary on this point. It's at page 2837. I don't take you to it, but you might care to look at it. The point the author makes, which I adopt is that there are decisive practical advantages to granting relief by way of injunction rather than allowing a petition to be brought and then dismissed, because the mere presentation and publication of a petition can do economic harm to the company. Now, similarly, proceeding with an adjudication which exposes one of the parties, the other party, to at the very least liability for adjudicators' fees and expenses, exposes him, if he participates, to the expenditure of costs which he's not likely to recover even if he's successful, is likewise economic prejudice which can be avoided if the court intervenes early by way of injunction jurisdiction rather than leaving it to be determined as a matter of enforcement. And my lord, we've included in the bundle the decision of the Court of Appeal in Stonegate Securities and Gregory at page 1342, simply as an example of the operation of that jurisdiction, the power to restrain the presentation of a winding up petition on a disputed debt. Perhaps if you would turn it up very quickly, it starts at page 1342. And at page 1345, in the judgment of Lord Justice Buckley, just below letter F, the learned judge set out the way in which, the principles upon which this jurisdiction is exercised. And if I can take it at G, if the creditor petitions in respect of a debt which he claims to be presently due and that claim is undisputed, the petition proceeds to hearing and adjudication in the normal way. But if the company in good faith and on substantial grounds disputes any liability in respect of the alleged debt, the petition will be dismissed, or if the matter is brought before a court before the petition is issued, its presentation will in normal circumstances be restrained. That is because a winding up petition is not a legitimate means of seeking to enforce payment of a debt which is bona fide disputed. And he quoted from the decision of Mr. Justice Ungod Thomas in Manning Goldstein. For my part, I prefer to rest the jurisdiction directly on the comparatively simple propositions that a creditor's petition can only be presented by a creditor, but the winding up jurisdiction is not for the purpose of deciding a disputed debt. And my lord, I draw attention to that because what the court is doing in here is identifying the purpose of a statutory scheme. Here, the statutory scheme for winding up companies, and restraining proceedings which were at odds with, not conformant with, that purpose. That is, my lord.
Ms. Sinclair, I noticed in Manning Goldstein that Mr. Justice Ungod Thomas ultimately puts it on the basis of abuse of process. But the question I want to ask you is this. There are a number of dicta to the effect that adjudication decisions are only actually quite rarely subsequently sought to be reopened by the unsuccessful party. I think there's one article, though the statistics aren't included in it, as long ago as 2014, that suggests it's only about 2%. And there are certainly dicta and authorities to the effect that very few decisions are challenged. If that's right, and if therefore the adjudication process often, indeed usually, resolves the underlying dispute, why should it be described as an exercise in futility merely because in an insolvency context it may not lead to interim enforcement?
My lord, two points in response, if I may. First of all, Lord Justice Buckley approved the reference, or did not approve the reference to abuse of process in that context, because he goes on to say, I adopt it, although I think it could equally well have ended at the reference to locus standi. But to get to your the heart of your lordship's question, Lord Justice Coulson in this case described the use of adjudication as a process to treat it as something akin to mediation or early neutral evaluation as an abuse of the adjudication process, because it is an abuse of the cost neutral character of adjudication. A party, unless he's agreed already in his contract to do so, never has to mediate. He's not forced to do it. He can choose whether or not he wants to invest his resources in that process. Likewise, early neutral evaluation or conciliation. But adjudication is different, because like it or not, a party may well find that he is going to be funding the adjudication, at least to the extent of adjudicators' fees and expenses, or if he takes part, he's going to have to incur his own costs. And that's something he has, as it were, been dragged into doing rather than freely choosing to do so. He didn't freely choose to do so at the beginning when he made his contract. It was imposed upon him by the Construction Act. The mandatory quality of adjudication in construction contracts that differentiates it from other sorts of what might be called alternative dispute resolution processes, even though many of them don't in themselves result in a resolution that can only facilitate.
Ms. Sinclair, can I just mention that you've overrun your time estimate?
I have.
Obviously, you can carry on and it can come out of your reply time, but I'm drawing to your attention, you may want to conclude your submissions sooner rather than later.
My Lord, I'm very grateful. My learned friend very kindly indicated to me earlier this morning that because he appreciated that a lot of my time this morning was going to be spent covering ground, going through the acts and so on, which would save him time, that he wasn't going to take a point on time. I did hope to finish by now. I will still finish, and I'm grateful for the indication. I think my Lord Hamlin might have had a question.
Yes, I mean, you said a number of times that adjudication is imposed on the parties. Here they chose to contractually incorporate the scheme, admittedly against the background of it otherwise be imposed, but it was a contractual corporation.
My Lord, their choice was confined. They either incorporated the scheme, or they incorporated something which would also have been equivalent to Section 108. It's the mandatory quality of Section 108 which requires an adjudication regime to be incorporated in the contract.
Yes, but we don't know precisely why they incorporated it. It may have been because they wanted it.
Well, it wasn't because they freely chose it, my Lord. They may or may not have welcomed it, but they didn't freely choose it. They didn't have a choice. They had to include adjudication in their contract under the Act. Now, my Lord, I apprehend that there might not be much between my learned friend and I on the principles, if it is appropriate to take those principles from anti-suit injunctions and anti-arbitration injunctions. I'll wait and see what he says about that, but on the assumption that we agree, then I think I can take the balance of my submissions very, very shortly. The assumption is that we agree that in those contexts, the courts will not restrain proceedings unless there is an infringement of the claimant's legal or equitable right of some character, or the proceedings in question can be characterised as vexatious or oppressive. Now, we don't suggest that this is a case where there is the adjudication infringed any right of the claimant. But we do say that adjudication in these circumstances can be characterised as vexatious or oppressive, because on the authorities, proceedings which will fail can be characterised as vexatious or oppressive. And we've set out the references for that at paragraph 116 of our written case at page 226. We say the adjudication here was vexatious or oppressive for three reasons. First of all, again, it's a misuse of the process. Adjudication is designed, was introduced in order to produce enforceable decisions. An adjudication which everybody knows is not going to do that is an adjudication in which the process has failed to achieve the purpose for which it was introduced. Inevitably, therefore, an adjudication which results in a decision in favour of a company in liquidation will be an exercise in futility. Secondly, it's oppressive because, as Lord Coulson recognised in his judgment, because it is a costs neutral process, and the referring party is, as it were, taking advantage of the fact that it can benefit from funding to a degree from the responding party, whether the responding party likes it or not. The responding party, however successful after the adjudication it is, whether in resisting enforcement or in securing a final determination in its failure, it is not going to have the benefit of the statutory set-off. It's going to have to prove in the liquidation for a dividend. And thirdly, go back to the fees and expenses point, as distinct from costs of the adjudication, even if, as my Lord Briggs pointed out, even if one takes into account that the liquidator's portion of the fees and expenses will be treated as a relatively high-ranking debt, they will still rank after fixed charge creditors. There still need to be assets in the company to pay them. And in the present case, my lords, as you've seen, like it or not, half of the adjudicator's fees and expenses had to be paid by Lonsdale in any case. Now, in the Court of Appeal, in addition to those central considerations, the court identified wider concerns. Those are set out in the judgment of the Court of Appeal at paragraphs 48 to 52 on page 258, paragraph 59 at page 260. In Bresco's written case, paragraph 170, it mounts 5 criticisms, which we've addressed in our written case at paragraphs 134 to 143. I will, if I may, leave to reply on those when I've heard how Mr. Arden maintains them, if he does. There is one final point which, very quickly, if I may, I do need to address. Bresco, in their written case, challenge the Court of Appeal's conclusion that there would be prejudice to Lonsdale because of the risk that Lonsdale would recover only a dividend or not at all in relation to its costs of the proceedings and any principal sum awarded to it on a final determination. At paragraph 167 of its written case, Bresco suggests that there is not, or there is less prejudice because Lonsdale's right to repayment, if it secured a final determination in its favour, would be a restitutionary right, a right to a remedy in unjust enrichment, which would be treated as expenses of the liquidation. My Lords, I took you this morning to Aspect and Higgins, which makes clear in my submission on the authority of a decision of this court that the right to repayment of sums paid pursuant to an adjudication decision in the light of a favourable final determination is a contractual right. It arises by reason of an implied term, not a restitutionary right. And as such, that would be a provable debt and not an expense of the liquidation. It arises out of an obligation in a contract which existed before liquidation date. My Lords, I'm grateful for your patience in allowing me to run over my time slightly, but unless I can assist you further at this stage, that's what I propose to say.
Thank you very much indeed, Ms. Sinclair.
Thank you, my Lord.
Mr. Arden.
Lords, I wanted on the jurisdiction issues to reverse the learned friends, to take it in reverse, as it were, and deal with the insolvency questions first, and then consider, in the light of the outcome of that, the question of the or the extent of the extent of the jurisdiction under section 108, and I do it. That's the way my learned friend approached it in her written case, and I do it because it seems to us that you need to know what the effect, if any, is of insolvency set-off before you consider how it then interacts with section 108. Lords, can I just start with this, that we understand the reason that cases like Steen and Blake are being referred to, the reason they're relevant is because we understand Lonsdale's submission to be this in relation to insolvency set-off in the context of this case. The starting point is that it's engaged whenever both sides genuinely assert a claim against the other. And that's so regardless of whether the claim exists or whether the claim has a value. It's simply claim is asserted, and then you're immediately into the insolvency set-off world. Where it is engaged, we understand Lonsdale's case to be that the existing claims, whether they're shows in action or causes in action, or existing claims cease to exist, and they're replaced to a claim, replaced by a claim to a net balance. Now, I'm not sure whether Lonsdale is saying this in terms, but the submission, I think, is that the parties' existing claims go and they're replaced by just a new statutory claim under the rules for whatever the net balance is, whichever way it goes. But it's accepted by Lonsdale, as it was by the Court of Appeal, that for limited purposes, the parties' existing claims or shows as an action are treated as continuing to exist. The learned friend, I think, accepts, as she must, because this is what Steen and Blake says, that they are causes of action, are treated as existing, even though they've disappeared. They're treated as existing for the purposes of enabling a claimant to prosecute, to initiate court proceedings, and indeed for a defendant to set off and counterclaim. And the form of those proceedings will be a claim not to enforce the net balance, but a claim, for, as it were, for the original deemed to subsist claim, to which the deemed to subsist cross-claim will be set up and pleaded, and insolvency set-off will then be pleaded by way of a defence. And it's in that way that you, as it were, preserve the court's ability to take the account and to assess what in account terms would be the existence and value of items on each side of the account. But she said, well, that's fine, that's ordinary proceedings. Nevertheless, substantively, it's still a claim for the net balance, and that will be assessed in the context of those proceedings. I think Lonsdale also accepts that the same analysis applies to arbitration, although that's qualified slightly by the reference to the need for a suitably worded arbitration clause. Now, I understood from exchanges earlier this afternoon that an arbitration clause in identical terms to section 108 would be an arbitration in which, as it were, an arbitration where, in respect of which you can treat as continuing to exist the underlying claims that are otherwise extinguished by the process of insolvency settlement. However, she does not accept, I think, that sort of deeming or treating exercise can apply to adjudication. Now, learned friend has obviously has a number of arguments relating to the nature of the arbitration, which she indicates are arguments in support of a narrower construction, the arguments in support of the proposition that one should place a narrow construction on section 108 and the jurisdiction that it confers. But certainly as I understood her case, I'd understood that it was simply impossible or inappropriate, as it were, to treat adjudication or to deem for the purposes of adjudication, deem the existing claims to deem them or treat them as continuing for the purpose of an adjudication. And I'd understood that Lonsdale's case was that you cannot do that because the existing claims no longer exist. What you've got is a claim to a net balance, and that cannot be a claim under the contract under section 108. Now, if that's Leonard's friend's case, then it does raise some it immediately raises the question, well, why not? If you can deem something to continue to exist for the purposes of supplying a cause of action, as was the case in Steen and Blake, and you can deem something as continuing to exist for the purposes of satisfying an arbitration clause, then why not for the purposes of an adjudication provision? What's sense? Leaving aside the differences in process, what's the reason for the adjustment? Why is there that difference? Now, we say there is no difference. That to the extent that one has to treat things as continuing to exist for the purposes of ordinary actions and arbitration, well, then the same is equally applicable to a clause like section 108. But it does raise rather more sort of fundamental problems about the extent to which, or in a broader context, in the context of set-off, underlying claims either do exist or should be treated as existed in other contexts and for other purposes. Now, there are many judicial statements, including by Lord Justice Hoffman, as he then was in MS fashions and elsewhere, to the effect that the effect of insolvency set-off is simply to discharge pro tanto the existing claim, which suggests, well, it suggests exactly what it says, that it's simply a reduction. simply a reduction of a reduction of the claim against which the sum has been, against which the cross claim has been set off. Now, those sorts of statements seem to be consistent with a notion, a notion not that the existing claims cease to exist, or certainly don't cease to exist for all purposes, but they are simply reduced by the process of set-off. And that is consistent, that sort of approach is consistent with what is taken, again, expressed in many judicial statements, to be the policy behind insolvency set-off. It is said it enables the third party to use its indebtedness to the company as a form of security. So you can set off pound for pound against indebtedness to the company, what the company owes to the third party in diminution or extinction of the third party's liability to the company. And you can see that expression used, indeed, even in Steen and Blake at 251E to F, page 1305 of the bundle. And the purpose, or the policy purpose behind that, allowing set-off rather than being liable for the full amount of the company's claim but receiving only a dividend, is that it is just that you should be allowed to set off rather than be relegated, rather than see your claim relegated simply to the status of provable debt. And that policy, or that underlying policy, you see it often, Forster and Wilson is cited. You can see it in Guy and McIntyre. That's pages 2,600 to 2,601 of the bundles. And I'm not going to take these at the moment. Steen and Blake, again, in the passage that I've referred to, in Lehman in the Supreme Court, at 169, Lord Neuberger, and I think that's, it starts, no, sorry, it's page 900, not page 900 of the electronic bundles. Yes, sorry, there, and also in Count Thing. And Count Thing is a good statement of the principle because it states both its principles and its limits. And Lords, that's the passage which I think my learned friend referred to at paragraph 32 in the judgment of Lord Justice Etherton. That's page 896, page 896 of the electronic bundles. And perhaps I can just take Lordships back to that, page 896. And this is the passage where, I'll give you the I'm sorry, yes, it is 896, 32. The context of this, as your Lordships probably know, is this is in relation to, it's a position which now no longer arises because of the 2016 amendments. But this is a case where it was dealing with actually future debts on both sides. KSF had a future debt which had to be, for the purposes of set-off, had to be discounted back to the relevant date, with the discounted amount then being the amount which was taken into account for the purposes of set-off. And at first instance, Mr. Justice Norris had held that this was the amount, the discounted amount, was the amount which KSF could claim at the date upon which the debt became due in the future. And so essentially the argument was that it was discounted once and for all. So once it had been discounted for purposes of insolvency set off, that was it. That is the state in which it remained. Now, that was rejected. It was argued that that was required by the operation of insolvency set off, and then rejected by the Court of Appeal. But what one sees at 32 is that, as I said, it's the statement about the policy and its limits. The contention that or the case that I've just summarised was described as having no sensible policy rationale, inconsistent with basic principles and objectives of insolvency administration, not a policy objective of the procedures to remove or diminish the indebtedness of those liable to the company. On the contrary, one of the principal objectives is to preserve, where possible, maximise the value of the company's assets. Provisions for insolvency set-off are intended to promote speedy and efficient administration of the assets so as to enable distribution to be made as soon as possible. The purpose of insolvency set-off, so I've skipped a bit, has nothing to do with the release of liabilities owed to the company, save to the extent necessary to achieve those objectives. Now, if one looks at that last part, it is apposite in the sort of case that we have here. What is, as I said, what is said is that a contractual right to adjudicate, or statutory or contractual right in this case to adjudicate, has been lost by the operation of set-off because that has had the effect of eliminating the claim which is required, the underlying claim which is required to exist for the purposes of set-off. And so you've lost a contractual right in circumstances where that right essentially had nothing to do with set-off at all. Now, that then raises, as I said, it raises a sort of more, counting raises it in a different context, but one can see the same sorts of points arising, as I said, in a number of other contexts, including this one. And we thought that it would be helpful to have a look at some of those other contexts to see the extent to which set-off has this effect, and perhaps more relevantly, the extent to which it either doesn't, or it is, as it were, deemed or treated not to. In other words, the underlying cause of action is preserved or deemed to be preserved, so that those other rights can be exercised. Now, before I'll come back to that if I may, but before I do, I thought it'd be sensible if I started with the rules, because obviously it's a statutory insolvency set-off is statutory. Should start with the rules, but what I wanted to do is obviously go through the rules that particularly concern set-off, but also look at the rules more generally, and in particular the rules that relate to proof of debts, because that obviously, the rules on proof, that section is the context in which the insolvency set-off provisions arise or appear. Your Lordship has, it's the whole of Part 14 of the 2016 rules. And those are $570 of the electronic of the bundles. And it starts at 572, I'm sorry. And if I can just run, much of this will be familiar, but if I could just run through and just make some general points. The debts and so on are you find provable debts. The various definitions are all now in 14.1. 14.2 is the general rule: all claims are provable. And then again, the very general words which reflect the policy, which is that as much as possible is provable, although we know now that quite significant claims may not be. And then at 14.3, this is the provisions which start the proof process. And well, before I get to those, can I just perhaps just indicate one of the reasons that I'm taking your lordships to this is because when a learned friend makes points about the deficiencies of the adjudication system, she principally uses as her comparator arbitration and ordinary court proceedings. But, my lords, the paradigm case, and therefore probably the true comparator, but at any rate a very important one, is the proof process. Because that is what, in the ordinary course, and the rules envisage, that it will be in the course of that process that set-off comes to be dealt with. So if I can go back to proving a debt, 14.3 is the submission of a proof, with certain exceptions and certain deeming provisions and so on. So the start of the process is the creditor submitting a proof to the office holder. And then there are certain requirements as to what the proof should contain. And the requirements, the contents are actually pretty basic. Particulars of how name, address, and so on and so forth. But then if you pick up at D, the total amount of the creditor's claim, including VAT, as at the relevant date, less any payments made after that date in relation to the claim, any deduction under Rule 1420, well, that's trade and other discounts, and any adjustment by way of set-off in accordance with Rules 14.24 and 25. Well, if I just stop there, the reference to an adjustment is new. The original 490, the original rules didn't have that, but it is an interesting use of term. Two points really that are interesting about this. The first is it's that the first time that an account might need to be taken is the point at which the creditor submits the proof, and the creditor, as it were, does the proof or tries to, and then submits it to the office holder. But as I said, and so that is the first stage at which it may be dealt with. And it's also interesting to note the use of the term adjustment, because it looks like what has happened. Use those words in the ordinary meaning, is that to comply with that rule, you would simply say, the company owes me £100. I have a cross claim for 25, which is eligible for insolvency set-off. It satisfies all the requirements about mutuality, commensurability, and so on and so forth. I'm going to adjust my claim down by 25, and I will prove for the balance of my claim. So it's an adjustment to the £100. Just moving on then with the proof, the particulars of the proof, or what the proof must contain. Again, one can just sort of see, just by running one's eyes down the sub-paragraphs, that it's all fairly basic. If you've got some documents, you need to identify them, but only for the purposes of substantiating what you say. That's I. And actually, you don't need even to deliver it. You only need to deliver it if you're asked, if the office holder asks you under sub 14.42. what the office holder does have is the power under paragraph 3 to call for production and any other evidence which the office holder considers is necessary to substantiate the whole or any part of the claim. So at this point, this is what the office holder gets. And it encompasses both a one-way proof in and a case where there are two-way claims and set-off is engaged. Costs of proving, 14.5, it's essentially a cost-neutral process. Unless the court orders otherwise, the creditor under 14.5a bears its own costs, but under B, the costs of the office holder, as you would expect, are an expense. Once you've got the proof at 14.6, you have to allow them to be inspected by, amongst others, a creditor who's delivered a proof and a member or contributory. And so they're open for inspection. Now, then at 14.7, on the basis of what it's got, or what it's been able, what he or she has got or been able to extract, the office holder has to admit or reject, is entitled to admit or reject proof in whole or in part. And if it is rejected, then you tell the creditor that you have, and with a statement of reasons. Now, if I just pause there, that's the easy case in a relatively small insolvency, which indeed this one is. This is what the creditor will provide, proving creditor will provide, and this is what the office holder will get, and may well do his or her best on that basis. There'll probably be discussions between the parties. Very often it will be a slightly rough and ready process for the simple reason in any case where the estate has limited resources, there will not be it simply will not be cost effective to spend a lot of time and money over a relatively small claim. And so by and large, one would expect in that sort of case that the two sides will simply put their heads together, come up with a figure that both will find more or less acceptable. Maybe neither will be satisfied, but perhaps, and that will be it. Lords, there will then be potentially more complicated cases, which can range from perhaps a proof with multiple items, or multiple proofs from the same or many creditors, which raise perhaps a common issue, and stretching from a sort of from just a case of that nature to the sort of extreme, which is Lehman. Now, where you've got that sort of case, you may well get a case where the liquidator may well look at what he's got. Well, actually, it's not the proof process as it's set out here it's not so much that it's not designed to do it, but actually it would be sensible for me to try and do it not by myself, but in some other way. Now, a classic way of doing it, where you've got maybe a single proof with a difficult point of law or some large point, a difficult point of law, which is highly material to acceptance or non-acceptance, or where you've got multiple proofs raising a common issue. A way in which you might commonly deal with that is simply by applying to court for directions. And you can do that piecemeal. You could do it if there's a single issue, you could do it at once. If there are not, you might do it in stages. And Lehman's is a classic example of that. If you look at the waterfall litigation, you had waterfall 1, waterfall 2A, waterfall 2B, waterfall 2C, and then further applications for directions, which I think were sometimes enumerated and sometimes not, but were certainly up to Lord Briggs. Yes.
But, I mean, it might be said that the waterfalls cases were all once Lehman's was seen to be solvent, but there were an equally large number of piecemeal applications when Lehman's was still perceived to be insolvent, so that the full insolvency regime was assumed to apply. It's a point just really of detail.
You know, just I'm absolutely right, and I'm grateful. Exactly, if one looks at the sort of the Lehman litigation history, everything up to roughly 2000 and about 2013, or maybe a little slightly before, was premised on the basis that it was insolvent, and everything, pretty much everything thereafter, was about what to do with the surplus. And one can see, as I said, I mean, Lehman's is an extreme example, but there are many, many cases where this sort of piecemeal identification and determination of disputes as part of a process, as part of an ongoing process, it is adopted because it's simply a sensible and cost-effective way of dealing with the issues that arise. And the order in which they're dealt with is very often based on the hope that perhaps if you do issues 1 to 3 first, you might get to a point where actually the balance of the remainder of them can be settled. And actually, in fact, that is what in the end happened with Lehman's. As each stage of the waterfall litigation was completed, the differences between the parties became narrower and narrower. And so that in the end, 2018, although there was still outstanding litigation of a substantial nature, it got to the point where the parties were prepared to accept, or a sufficient number of the relevant parties were prepared to accept and vote in favour of the distribution scheme, which represented a compromise of the balance of the remaining undecided litigation. So one can see that. So that's the sort of, I mean, and you will see why I'm driving at what I'm driving at here. It's although ultimately a decision has to be made on a proof, the road or the means by which you get there can be varied. It's whatever is best adapted to the circumstances, and the choice, if there is a choice between different routes, will often be or will be one made by the office holder, obviously with advice and with assistance, and may represent a choice based on commercial and cost reasons between 2 or 3 alternatives. Now, that's then, so that is where one gets, or that's the point, as it were, that's where one gets to the decision, admission or rejection. As I've indicated, it can be, I think we've used the word, it's piecemeal or iterative, I think we preferred, but it can be, in an appropriate case, an iterative process. Now, there is then obviously an appeal, a right of appeal, and that's under 14.8. The creditor can obviously appeal, that's 14.81. So also can a member, contributory, or any other creditor, that's under 14.83. And then in either case, there is a very truncated time period, 21 days. Now, the timetable, the truncated period, I accept it doesn't apply at the earlier stage, but the reason for the truncated period and the reason why the courts are very reluctant to extend it is because it's recognised that a function, an important function of the liquidator, is not just to get in the assets and not just to ascertain the liabilities of the company. Those obviously are two very important functions. It's not only to make distributions, a third important function, but it's to do so quickly. Now, it's easy because many liquidations result in very small payouts to creditors, if any. It's easy to forget or easy to assume, well, that must be the case, or really that's the point about speed. Does it really matter? But in principle, it does, and in practice, it can do. What you're doing, the longer it takes, the more expensive it is, and the less, the more reduced the estate is by the costs. But it's also the longer it takes to distribute, the more, as it were, the more that the creditors who are entitled to the distribution suffer. They are the ones, they're deprived of the cash that they're deprived of the cash that they would otherwise have through a distribution by a delay. And in an extreme case, you can demonstrate that by a sort of time cost valuation. And again, going back to Lehman's, there was an interesting illustration in the context of the scheme, because although the creditors were going to get statutory interest at 8% per annum on the full amount of their debts, which by anybody's reckoning sounded pretty good, what they managed to demonstrate was actually it wasn't good enough, that if they only had their money back, then by various routes, they could demonstrate that they were far worse off, that the 8% came nowhere close to compensating them for being deprived of their money. So again, it's an extreme case, but it is an important point. There is a cost to creditors in delay, and therefore good reason for speed, even where that truncates, even where that requires strict enforcement of truncated timetables like appeals. Again, 14 on costs, 14.9, it's cost neutral. Again, the liquidator, sorry, no, not quite. It's cost neutral for the office holder unless the court orders otherwise. Now, one would have thought if this were the sort of, if this were a final sort of, if this were a set of proceedings, this would probably be where we stopped. I mean, that's it. You've had your first determination, although we would say pretty rough and ready, or can be, not always, but it can be. You've had your appeal, that's it. But that's not the case. 14.10, a creditor can withdraw a proof, and under 14.10.2, it can be varied. And so you can withdraw a proof for whatever reason, but if something has changed or something has been found out, something new, something that affects the value of the claim, it's capable of variation, 14.10.2. You've also then got the court's powers to exclude. And so after the proof has been admitted, say, if it appears to the office holder, having another look at it, that the proof shouldn't have been admitted or ought to be reduced, and if you can't get the creditor's agreement to vary, then the office holder can apply to court and get it, and have the proof either expunged or varied. But that's not limited to the office holder, because you can see under 14.11b that a creditor member or contributory can do it as well if the office holder declines to interfere. So on the application of one or more of 4 different parties, you can have a post determination expunging or reduction by application, simply on the grounds that that it's thought in retrospect that the proof shouldn't have been admitted or should be reduced. Then estimated value 14.14. This is the estimation rules my learned friend referred to, and you see referred to in Steen and Blake. Now, claims of that nature, contingent claims, unliquidated claims, things like that, have to be estimated. And it's the office holder that does it. And you do it for the purpose of proof, and you will also do it, as we'll see in a moment, you also do it for the purposes of set-off. But circumstances change. And so, under 14.2, you can revise. And so if a contingency falls in, and you've estimated by reference to it the possibility that it will, so say that you've estimated a contingent liability at 10%, but the contingency subsequently happens, you revise under 14.42. And so again, I've referred to the iterative nature of the if proof process in the context of how you get to the determination of the proof. But that iterative nature continues in the way in which I've already drawn attention to, by the ability to expunge and reduce and so on. But also, as soon as one's talking about estimation, again, it's iterative. When you put an estimate on something, that will be the figure that's taken, obviously. So in that sense, it's final. But it's always capable of revision and must be revised if it turns out that your earlier revision has been overtaken by events. And so you see that reflected in 14.4 in the case of estimated debts. It's the amount provable. The amount provable is that of the estimate for the time, simply as the estimate for the time being. Well, secured creditors have their own regime, but again, there is a process by which you value, and you can change value, sale, and so on and so forth. If I can just skip that, I think that's probably too much detail. 1421 debts in a foreign currency. I'll leave that. I'll leave that for the moment. Periodical payments I don't need. Lord's interest, I refer to that for this reason. 14.23 tells you what a creditor with approved debt can prove for by way of contractual interest. And essentially there is a cut-off date. So you can prove for contractual interest accrued up to the relevant date, but no more. And then that, in a sense, is the end of a creditor's interests. In interest, it's simply ruled off unless there's a surplus, in which case, in the case of a distributing administration, the regime in 1423(7) applies, and in a liquidation, it's still in the statute section 1892. But essentially, what you get in the surplus, in a case of a surplus, is the greater of the it's the greater of the judgments rate, or the contractual rate, the rate that would have applied apart from administration. Now, there is, if I just pause there for a moment, none of this, of course, affects the companies at this point, affects the company's outgoing claims. These are completely unaffected at this point by these provisions. And so the company has whatever rights it has under the contract, whatever right to interest it has under the contract or contracts, and whatever rights it has to adjudicate or arbitration. I think Learned Friend accepted that. And so at this point, and ignoring the provisions we're about to come to, the company is simply, you can see how it works for the creditor and the nature of that process. The company is simply unaffected in all respects. Well, that leads me to 14.25. Mr. Shaw, who's 6 feet plus, just over 6 feet away from me on my left, has just sort of pointed out it's now about just coming up for 4 o'clock. If that's a convenient moment, then I can stop there, pick up on set off, and I think having sort of laid quite a lot of ground, I can begin to move rather more quickly than I have been up to this.
Yes. Well, I don't think you've been taking things unduly slowly at all, Mr. Arden. It's been very helpful.
I'm grateful, thank you.
This is a convenient point for us to adjourn, so we'll adjourn now and resume at 10:30 tomorrow morning.
Thank you very much, Martin.